Court will call cause number CVDO 21-63, Strickland versus iHeartMedia Schaefer, for purposes of a challenge to the statement of inability to pay court cost for appeal or post bond. What say the parties? Court would note that there's one other participant online. It's an 830.376 number. No other parties are present. That person, whoever that is muted and is not participating in the hearing. Mr. Schaefer's just joined us. Mr. Schaefer, can you hear me?
Hello, Judge Emerson. Yes, I can.
Okay. All right. The case has already been called. The only other party that's present on the screen, it looks like it's an 830 phone number with the last three digits of 376, but they didn't answer when I asked for purposes of the parties, so I'm not sure who that is. Is that a witness that you've called by any chance?
He hasn't called. Has I called? Have I called? Or I'm sorry, what's your question, Judge?
Is that a party that you've called, or? Because
I can only assume that
the Zoom hearing is the reason I'm asking.
Yeah, that's Roland numbers, or Roland Strickland. That looks like his cell phone number.
Okay, then we'll leave them online, but they are muted and there is no video to go with it.
Okay.
You can hear me on the 376 number. I need you to please turn on your video. All right, Mr. Schaefer, nobody's responding. Nobody's answered on behalf of Mr. Strickland. What do you have to present today?
Judge, thank you very much. I have filed a contest to Mr. Strickland's affidavit. I think in the old days, back when you and I were in law school, they called it a pauper's affidavit, and I understand they changed the name. And I'm contesting that affidavit, and I'm here to present reason and evidence and cause to you, Judge, to show why that sworn statement should be denied. I think it is a fraud upon the court, to be candid. There are three reasons I think you should grant our contest to his affidavit. In summary, one is that he omitted on the form required by your court, which was promulgated by the Supreme Court of Texas, he omitted the most critical information. And we have learned it was intentionally omitted. The reason I know that is this very same hearing with the very same form and the very same information he filed in Travis County, Texas, in that other case, the sister case associated with this one. And we had a hearing just like this, and Mr. Strickland had his full day in court, and he lost the case. The judge denied his pauper's affidavit for fraud. Well, I don't know why he had denied it, Judge, but I think in large part it was because of the material omissions on his affidavit that he left off. And so his affidavit was denied by the court, and he has to pay his own appellate costs in that case. The reason I say he knows is because he was made aware before that hearing of his omissions, which were bank accounts he didn't list, stocks and bonds, anything to do with a bank or financial information, he left blank. He also did not list that he had 3 trailers. He didn't list all his property. He didn't list the money that he gets for his brother's disability, and some other matters I'm going to get into in just a moment. But the point is, Judge, he didn't correct it in your court. He filed the very same thing, and it was pointed out that this is incomplete. And he hasn't amended or changed a single thing. And one might wonder, Judge, if that was intentional, because I also sent him discovery out of the Texas State Bar Collection Manual. I sent him interrogatories, and if you've ever seen those before in your private practice, they're very thorough, and they're approved by the Supreme Court as well. And he didn't answer those willfully. He wrote me an email saying, I'm not going to answer them. Into his assets. So he's hiding his assets from the court, Judge. He wants to take advantage of the rules when it serves his interest. In this case, by filing an appeal. Parties are entitled to file an appeal. But if it comes to the requirements of the Supreme Court of Texas in your court, to fill out a very simple affidavit, but it lists very specific things. I know you can probably recite it by heart. He won't. He's not going to play by the rules. And Judge, the argument whether he's indigent or not, if he's not going to play by the rules when he has to, but then he asked for the state of Texas to pay for what is a frivolous appeal. Both lawsuits were dismissed for failing to state a cause of action, and he knew they didn't state a cause of action. The taxpayers or whoever finances his frivolous appeals, whether it's the state of Texas, which I think would ultimately be the taxpayers or whoever pays it, it's not him. Judge, I don't think his affidavit should stand up if he's not going to play by the rules of the court. And this is an affidavit for you, Judge, for the 198th. And he did not list we found out later, Judge, I did an asset check on him, paid money for it. He's got an account at Hondo National Bank. He has a debit card. He says he hasn't worked since 1996. So for 25 years, he's been unemployed. How does a person live for 25 years with no job? The only source of income, he says he has no income on the form to you, Judge, but he says he's been named the payee for his brother, who does get some kind of disability check for mental disability. He won't tell us how much that is, but I think he's been living off his brother's check for 25 years or so. I don't know. The point is he was supposed to answer those questions. And so anyway, Judge, back on the three reasons. One, he's omitted critical information that you require, the 198th in the state of Texas requires for his affidavit of his inability to afford the cost of an appeal or the bond. He's omitted information and refused to complete that form under oath. Number two, Judge, I'm no great legal scholar, but I do think the thought res judicata came up to me. There's a Travis County judge that heard this same matter with the exact same form, with the exact same omissions, involving the same transaction and series of events that is in the 198th Judicial Court. And that judge ruled that affidavit that Strickland filed, which is virtually the same as the one before you, Judge, today, he just said, no, this isn't going to stand, and he denied it. And I sent a copy to the court. It's in my, attached as an exhibit. I think that ruling by the court, because it involved the same parties, Strickland had his full day, same party, same transaction, same case, really, with iHeartMedia. I think that constitutes res judicata. At a minimum, I asked the court to take judicial notice of the judge who heard that case, which wasn't the original justice of the peace course. That judge was out of town. The one that Strickland made a big deal about with the songs and whatever. This was another judge from another precinct, fresh. So I think, Judge, I just asked you judicial notice. If not, make a finding of res judicata. You don't have to, but I think you, you see the point I'm making. The third reason is that Mr. Strickland, I sent him those collection interrogatories for this hearing. They were due August 16, 2021, plenty of time for today. And he wrote me an email, 2 emails, saying he's not going to answer them because it's none of my business. And I have to provide a reason to him for each and every interrogatory why he has to answer them. Judge, I don't think there's anything that requires me to even respond to those emails, and I did not. By the process of law, he has to answer those interrogatories or filed objections, which he did not do. So his objections have been waived. He didn't make any objections, but it's too late now. And he didn't request an extension of time. He just said, I'm not going to answer those. So this guy clearly doesn't want to divulge his resources to the court. And I think just by that fact alone, it's game over. He has to complete that form so that you can look at it and make a determination. And he has to answer those interrogatories. He hadn't done either purposely. And so he's not wanting to play by the rules. So I think he should get his free pass out of this court. And I think that his affidavit should be denied, and that my motion and iHeartMedia's motion should be granted. Judge, I don't know if I need to go any further. I know you're very limited on time right now. I have a whole, supplement that I filed that gets into great detail about the fact that he does have a bank account and a debit card. He's spent money on this case. He spent money in the contest using that debit card. He won't tell us the bank account number. And that's just one bank, Hondo National Bank. You won't find that on the form that he's provided you to say, hey, I shouldn't have paid any appellate costs. He didn't even tell you he had a bank account. We would want to know what's in that bank account. We'd want to look at the transactions, deposits, withdrawals. He's not going to provide that. So anyways, also he has a studio, he has a company. He put out a CD. He didn't put that down. A commercial CD from his band. He didn't put that on the form to you. Does he make any money off that CD? That's the purpose of a CD, royalties. He's bragged about his band in the Bandera Bulletin. And I just think he needs to tell us under, or rather Judge tell you under oath about this CD or any other royalties he gets. He's a musician. So he says, but what he did not provide you with, Judge, and I'm just flipping through my motion, he didn't provide his income from public benefits per month. That's one of the top 2 on that Supreme Court form. He gets $220 a month, and he has for years while living in Texas from California General Relief Fund. He came here from LA, California. And when he was in California, he applied for these general relief funds, telling them he didn't have any money. He moved to Texas in the 1990s and didn't in writing tell California that he was no longer resident there, Judge. And I don't think a person can take state benefits on welfare when you don't even live in that state. Now, he told the judge in Travis County, well, I called him and told him. And you know what? They just kept sending me the checks, even though I told them I was in Texas. And an honest person under those circumstances, when they start, if I was in California, moved to Texas, and I'm still getting food stamps from California or whatever it's for, I would send those checks back. And I would contact them and say, guys, look, again, I've moved. Here's your money back. I don't live in California anymore. Well, he didn't do that. He kept cashing those checks, and as far as I know, to this day, still does. Well, recently, and oh, by the way, he also collects Texas snaps. He gets food stamps from Texas, so he's collecting food stamps from 2 states. I think that's fraud, Judge, and I would suggest it's probably a felony to be doing that. And he's lying to both states about his public benefits. And he now has gone back to California, but right before he left, he filed a homestead here in Texas for his property. And I think he did that because, well, he has 2 judgments against him right now. So he files this homestead, which could be false and fraudulent too, because he doesn't live in Texas anymore. He lives in California. He gave Christine McIntyre his new address. So he's trying to claim, and I know why he went back to California. It was actually the day we had the Travis County hearing on this same affidavit. He was driving across the country with his brother because he told the judge, yeah, they've been calling me a whole lot. I think they've kind of figured out what's going on. And he goes, I got to go over there and take care of business. Days later, all of a sudden, he's living in California. And I can only imagine what he told California. My imagination says, oh, I went to Texas in just a little while. No, California, that's my homie. I'm good. I wasn't frauding y'all. Well, then he's frauding Texas because he's still collecting. He has food stamps from SNAP from Texas. I suggest to the court that a man that would lie to the state of California for maybe over a decade, accepting those monies or more, and a man that would lie to the state of Texas is a man that would lie to a Texas state district judge. I don't think Mr. Strickland can be believed. He didn't state his income from people in his household each month, which is his brother. He didn't provide that to the court. Income from another member of his household, didn't finish that. His total monthly income had put down. He didn't list his bank accounts or other financial assets, and he didn't list 3 trailers that he has. We had to find these out within a private investigation. So he didn't list again that he gets $220 a month from California. He didn't tell you that, Judge, even though there's a specific question. So we have a hard asset report we did on him. It looked like there was a house that he owned in Fort Worth in Tarrant County that he sold, and it appeared he got $90,000 from that. And this was a couple of years ago. But Judge, I'm going to ask you not to consider that because I'm looking at the report and it's hard for me to determine if he was the seller on that. So I have that in my supplement, but I'm going to ask you to disregard it because I'm not absolutely sure about that. I think that, in all fairness to Mr. Strickland. The raised judicata, judicial notice, I've told you, I've talked about that. And there is no reason other than a not acceptable reason for him to not fill out the form for you to look at to accurately determine what his financial status is. And I think it's unfair to the state of Texas. It's unfair to the citizens of this state, the taxpayers. It's unfair to my client that if he's going to appeal this frivolous case with a frivolous appeal, I think he needs to foot the bill for that. And particularly since he's failed to provide, Your Honor, with the information that you need, more than need, why, Judge. So that's my argument, Judge, and I pray to the court that our challenge or contest of his affidavit of inability to pay appellate costs be granted, and that Mr. Strickland's affidavit that he submitted to the court be denied. That is all, Your Honor.
Thank you, Mr. Schaefer. Mr. Strickland, are you with us? Okay, the court would note for purposes of the record that we do have that participant that's at the 830 and the last three digits are 376 phone number that I believe Mr. Schaefer referred to early on is a phone belonging or Mr. Strickland having access to. Mr. Strickland has not participated. There's no video stream. When asked to initially at the start of the case whether they were prepared to proceed, there was no response from that number, nor has there been any proffer of evidence from that number during the hearing. At this time, the court will sustain the contest to the indigency affidavit, will deny the indigency for purposes of appeal. And if Mr. Strickland, if you want to pursue your appeal, you're going to have to pay your court cost and the bond that's associated with it. And as you already know from your Travis County case, if you want to appeal the court's order, you certainly have a right to do so. Mr. Schaefer, can you get us a court order?
Yes, Your Honor, I will. I'll have one to you shortly.
All right. All parties